All right, welcome everyone to today's session on understanding SMSF deeds. My name is Aaron Dunn, and it's a topic that really comes off the back of the fact that deed upgrades are one of the most common documents we have on our platform. And whilst in theory it appears straightforward, there are a number of considerations that we need to go through. So it just provides us with an opportune time to take a step back from this deed upgrade process and to identify all the things that you need to be looking for as a practitioner as you work through this process. And as we go through this today, we're going to unpack for you a number of things to help you understand whether now might be the right time to consider changes. And in a lot of instances, many people won't have done changes for their SMSF clients probably since 2016 or 17 as a broad concept. Some people quite clearly would have made changes for certain clients along the way for a range of measures, and things like downsizer contributions is a good example there as well. But then from there, once we start to understand, well, there is a change that might warrant us looking at this within our client base, we then have to step ourselves through into things like, well, how is this actually going to occur? So that may be practically where you go, well, look, we don't want to be involved in this process, and therefore we want that responsibility to be done by a relevant provider, legal provider, or other sort of service provider through that approach, subject to how you obviously complete that task. But equally important to this is that if you are involved in the ordering process, the capturing of the data to enable this legal document to be prepared, is that you understand who's who in the zoo when it comes to the powers of this variation actually occurring. So we're going to be exploring that sort of stuff. We're going to be looking at pre-existing arrangements within an update process. The legacy pension conversion rules in December has really drawn this issue out, because for a lot of clients, the powers to pay those market-linked pensions, lifetime complying pensions, flexi pensions, fixed-term pensions, I should say, compliant pensions, these were all built in the the early 2000s, somewhere between probably 99 at the earliest through to sort of 2004. And they had very prescriptive rules. So again, just how we deal with these sorts of scenarios as part of the overall process. Now, one of the things that I constantly talk to people about is that if you're going to be doing a deed upgrade, then you need to ensure with a corporate trustee that you have absolute alignment between the rules of the company, i.e. the constitution, along with the rules of the fund. And I'll talk to why that is important about the overall process. We'll have a look at the Smarter SMSF deed and the rules around that and the process of ordering. We'll also touch on some of the ways in which you can utilize things like our Smarter Legal Review throughout that process. And the other aspect to this that I did want to touch on is when we have clients update the deeds, then in the modern day, how can we actually execute these documents? We have seen through the COVID period, the temporary relief around electronic signing, a lot of that has become permanent, but there are things that we need to consider that don't necessarily make this a straightforward process. And then we'll finish off with a number of other important considerations. So why is this such an important topic? Well, we know quite clearly that the deed acts as the engine for your client's SMSF to deal with the decisions of the fund. How we manage the risk and optimize the strategies ultimately all comes down to the way in which the law operates, and then therefore how our deed applies those elements of the law. And it's when we look at an older deed, and someone that looks at this literally every day, we start to see problems arise where we have a conflict with the current law. It doesn't allow us to do certain things. And I keep coming back to something like downsizer contributions, which where many of us did those updates in 2016-17, and then those laws didn't come in until 1 July 2018. And therefore, we might be looking at that as a strategy for a client, but unless the deed allows for us to accept that contribution, then we wouldn't be able to undertake that particular strategy. And again, that connection back around decision-making to the company constitution. Broadly speaking, again, those funds that were established prior to the 30th of June 2017 should have gone through some sort of process around upgrading the governing rules at that point in time. There were enough legislative changes under those superannuation reform measures that looked at ultimately a change that would need to be incorporated into the rules. So things like the introduction of the transfer balance cap, a whole range of new terminology came about because of that. We had differences between how benefits are treated as a member-based benefit versus a death benefit payment and what you could do in respect to those different measures as well. So that should be one of the first prompts for you, that if you see clients that have deeds that are typically predating 30 June 2017, then ordinarily there are going to be gaps within that deed that should require you to contemplate that upgrading at this point in time. So then it raises the interesting question, well, how often should you update an SMSF deed? And we're going to kind of work through that process for you today, and why, therefore, is it important to maintain the currency of those ongoing changes. And I show you this next slide just to highlight how often we see change going on in the SMSF industry. And I've highlighted a couple of things here because we do see throughout each of the decades some fairly substantial major reform, as we did in 2006, 2007. So 1 July 2017, our Better Super or Simpler Super reforms, as it was called then. We then also saw that superannuation reform in 2017. But equally, we saw things like limited recourse borrowing arrangements in 2010 get revised, and therefore we needed to update at that point in time, and they started as instalment warrants back in 2007. Now, whilst a lot of you probably haven't looked at changes since those reforms in 2017, there have been, as I've highlighted on the right-hand side, a significant number of things that we would need to contemplate in a current deed. And these are things that certainly us at Smarter SMSF have built into the deed since that point in time. I go back to the comment around downsizer contributions that you can see at the bottom of that 2010 to 2020 year there. We saw changes to the number of members in a self-managed fund. We saw compulsory introduction of SuperStream, not only for contributions, but around rollovers. We've seen electronic execution measures in respect to a number of SMSF requirements. We've seen commutation rules adjusted for things like market-linked pensions, as we have seen more recently around the legacy pension conversion amnesty. And of course, more over this last few years, we've seen a number of case law decisions around dealing with superannuation death benefits, most notably the Hill and Zuda High Court decision that affirmed the operation of binding death benefit nominations. And therefore, there's a number of things in here that you can see that clients ordinarily need to ensure that that deed allows for these sorts of things. We aren't just assuming that these things can occur, and a lot of that will boil down to, is the deed quite prescriptive in terms of how certain rules and clauses will operate in accordance with the way in which the laws and regulations have been drafted, or are they broad enough to allow for these things to occur? And think something like the legacy pensions to enable things like asset test exemption at the time, you will find those deeds were very prescriptive because that's what was required at that point in time. When we compare that to something like a form and way in which a pension can be paid today as an accounts-based pension. So when we look at considerations here in the deed update process, what do we actually need to look for? So first and foremost, it's really understanding what that motivation or need is for the update to occur. I've already spoken about what that might be, and the previous slide really highlighted what a motivation may be in your eyes for your clients, or in the eyes of the client anyway, from an advice process. And from there, it needs you to think about, well, are we going to make wholesale changes to the fund's governing rules? So effectively out with the old and in with the new. Or are we simply going to be altering specific rules within the existing deed? Now, there may be circumstances where you may do it. I would say, whilst that occurs, it would be in the minority of situations, because ordinarily you're looking at a simplified process to replace all of the rules of the fund. But it is worth noting that you need to contemplate which approach you may want to take, because there may be other specific legal work that has been done that would simply make sense to introduce specific rules there. You may have restrictions around who could become a member of the fund, for example, and a whole of replacement may then open that up. And you may not want to do that in certain scenarios. And then from there, once we understand the motivation, whether we're going to be doing a whole of replacement deed, or whether we're going to be adjusting specific rules, it then comes down to form and process. So what do we need to understand about how this pension can change? So why we need it to change, what it's going to change to, and now it's how does this process actually have to work? So in some instances, you may see that be allowed by simple resolution. Ordinarily, you're going to find terminology within the existing deed that would say, to allow for a variation to occur to these rules, that would need to be undertaken by deed. And in that instance, therefore, we are referencing the fact that we need a deed of variation that would allow for that change to occur. There may be some other methods there, but typically they're the approaches that you're going to see. And then once we work out how that process works, well, who is then involved in that process? So who holds the powers here for that deed to be validly updated? And this is where a lot of people can get unstuck in this deed upgrade process. Do the powers rest with the trustee to be able to make these decisions? Do the powers rest with the member or members to make this decision? Or do the powers rest with both of them ultimately to make that decision? And a lot of this then comes down to who needs to be involved in the execution of that deed of variation. But it doesn't stop there, because historically we have seen other parties that can be attached to the deed. We may have, with older deeds, the fact that it needs to seek the approval of the principal employer, or it could be the founder. So in that instance, you would not only need a trustee or a member or both of those, but you would also need the principal employer to sign, or the founder. And it's probably happened twice, 2 or 3 times in the last month or two, where we've actually seen that principal employer or employer sponsor still be a party to that deed. But ultimately what's happened is that employer sponsor has been wound up or no longer exists, or the individuals aren't involved in that process. So making sure you keep up to speed with what's happening, not only around the fund, but naturally the documents with that fund, because that becomes a much more difficult process to unwind that arrangement and remove those parties as part of that overall process. And the final piece here is to always go back and check historically what's happening in the fund. Because whilst we may see that the powers under the previous deed talk about the fact that they rest with the trustee of the fund, quite often we see situations whereby there has been a principal employer, employer sponsor, founder in place, but a deed update that has happened in the past actually hasn't removed them. So therefore, we have an invalid deed that has occurred that we're trying to do the update from, which effectively is just compounding that problem around the validity of the deed. So you've seen a couple of times on this slide, I talk about the word validly, right? It is absolutely crucial. In all the cases that we see through our training that we provide here at Smarter SMSF, a lot of the questions around the payment of superannuation death benefits and the decisions that are made, the courts will first go to the deeds and determine what is the operative deed for them to then make their decisions around the facts of each particular case. So it is crucial that you've checked the history of the updates. So what does the document trail tell us about the parties involved? So was there someone else that was requiring approval in this process? And if there were, are they still required, or have they been formally removed in accordance with whatever that process allowed for them to do as well? So again, just making sure you've got all the steps in sequence here to enable that deed process to occur. Now, I touched on earlier as well the fact that we may have pre-existing arrangements inside different deeds. So situations do exist where legacy rules or clauses are ultimately required to carry through to deal with different things. It may be around pensions, so the market-linked pensions or the defined benefit pensions, as I highlighted before as part of this legacy pensions amnesty, is something that is crucial, because to continue to get that asset test exemption, we needed to ensure that those clauses to allow for that asset test exemption to ultimately carry through. Equally, that can apply with the way in which a binding death benefit nomination may have been structured as well. So typically, where we have that whole of replacement of the governing rules, we would then see those provisions being overridden by what we have in the current deed. So therefore, when you are looking at a variation to that deed, you are wanting to ensure that that variation includes reference to the fact that these rules that are important to that overall process around the pension, around the nomination or whatever, remains in place and ultimately continues on and remains binding upon the trustee as well. So just a step that we want to make sure that we have in place, so that those things that were important, crucial to the existing arrangements carry through to the new deed. Not that they sit in the deed itself, but the variation acknowledges those and allow for that to carry through. So then the question comes about around the fact that we may have a defective deed in place. And what does that ultimately mean where we have that break in the chain? Because there will be situations as you start to look at a deed update process for your clients where you'll say, actually, you know what? There's actually a problem here. Now, you might not know entirely what that problem is. You might not know how to fix that problem, but you know or think that there's a problem. And the reality is that the problem, the break in the chain, ultimately means that we have an invalid deed update that has happened any time after that break has ultimately occurred. Now, that break could be as simple as the break in the chain could be as simple as, well, we can't find a deed, or we can't find part of a deed. So the documents have been scanned, but they haven't been scanned correctly. We haven't been able to obtain stuff from a previous accountant. There's a number of things that ultimately we have a defective issue. And that therefore invalidates any subsequent deed and the documents that were prepared under that purported operative deed. So a good example there is if we put in place a binding death benefit nomination under what we thought was the deed that was in play, but is subsequently found that the previous deed update that occurred wasn't done correctly, well, then we have issues of the fact that that binding death benefit nomination is invalid. Or if we've tried to update and change the trustee of the fund, there will be a question of fact as to who may be the correct trustee of the fund. And we have seen recent decisions made where funds have had to go to the court to determine whether or what trustee is actually on foot, what deed may or may not be operative, and then therefore what death benefit nomination would be relevant to be able to have that trustee ultimately make decisions around the payment of the superannuation death benefit. And having to go to the Supreme Court for those sort of things certainly is a very expensive exercise. Now, there is the ability, of course, to go through and undertake some form of rectification. Okay, now that rectification will assist in trying to remedy that particular update. And you can use rectification across a number of documents, whether that's a deed itself, it might be through an LRBA, it could be a number of those sort of legal documents. And we do have that through our Smarter Legal Review process. But if we look specifically at the deed, it may be that we've found a typographical error through the name of someone. It could be that we've got some missing details. So it hasn't been dated. It may be missing a relevant signature. Or again, it comes back to the fact that there was a process that was missed as part of that upgrade. And therefore, we need to remedy that before we move on to the next phase of that particular approach. So we do, and we have built our Smarter Legal Review here to enable you to remedy those legal issues prior to then going into that actual deed update process. Now, the other thing that I wanted to talk to today is just ensuring that we have absolute alignment as well to our company constitution, because in the large majority of SMSFs that we have in Australia, we have corporate trustees in place. And whilst historically we may have seen upgrades occur, going back to our table earlier of the changes in superannuation law, we may have seen upgrades happen once, twice, 3 times, 5 times, 10 times even. But how often have we gone back and looked at the company constitution that acts as the decision-making document for the trustee of the fund, noting that those individuals will be directors and then ultimately shareholders. So it is crucial, in my view, that when you are going through that deed upgrade process, that you are also reviewing the constitution. And changing a supplier is certainly an area that would warrant that. So if you're an existing Smarter SMSF client and you use the Smarter SMSF deed as part of that process, it's not something that you would need to go and update that constitution each and every time, unless there was something substantial that we advised through our change log around that process. But if you are changing a provider to ultimately update to a Smarter SMSF deed, making sure there's an alignment in decision-making is crucial, okay? Because in many instances, you can end up with a very different set of rules that will deal with decision-making and voting compared to what the other provider may have done. So is decision-making simply done on simple majority, but is voting then looked at as one vote per director or shareholder? Or is it based upon a dollar of members' account balance? Or is it a combination of those two, but then you have a deadlock provision that may allow for members to decide based upon the dollar of account balance that they may have? So there are some decisions here, or some important considerations that I've sort of raised here, and I've only just touched and scratched the surface around a couple of those, that highlight why the alignment of those things absolutely makes sense. Now, the other thing, and it sounds pretty obvious, I'm assuming, to many of you that work within the SMSF space, but it's not uncommon that we still see the fact that we have an entity that might be wearing multiple hats, and therefore they're not a special purpose company. And in that instance, it's really understanding the rules that sit within that entity that will highlight why you would put in place a special purpose trustee entity in the first place. So typically, the key area that you're going to find that will pose the greatest risk is around the lack of powers that deal with succession inside that company. So in the event that the individual loses capacity, or in the event of death, there will be, now I'd find it, what's the word I'm after? I'd find it unlikely that there would be powers in there that would deal with the appointment of the LPR in the event of death, or the enduring power of attorney in the event of incapacity. And also things like decision-making when someone may go overseas from a residency point of view as well. So again, just thinking about those few things as part of that deed upgrade process as well. And we do have a change of company constitution document that is available. It's a fairly straightforward process, because within the Corporations Act, you can have at least a 75% majority approve for that to occur, and then ultimately the adoption of those new constitution of governing rules, in essence, for that company can apply as well. So let's keep moving on, and I just want to highlight a couple of things before we jump into the platform about the Smarter SMSF deed. Now, as a business, we own and manage all of the IP around that deed and also the platform that goes with it. We utilise an Australian legal practitioner that we appoint through Smarter SMSF. Many of you will know and have seen present Chris Hill through Hill Legal for us as well. We not only within the deed have the ability for you to update that to meet the requirements as a standard SMSF, but equally we have our QROPS deed that allows for things like UK pension transfers. So not only can you order that in the context of a brand new SMSF, but you can also select that QROPS option as part of the ordering process as well. Now, when you order, there is naturally full version control over the deed changes, and we do have a change log that keeps you up to speed with everything that's going on in respect to those changes as well. So I might just take this first opportunity to go over there and just to highlight what that change log does, so you can then see in our knowledge base. It walks you through what those particular amendments are at certain points in time, and will allow you to make the relevant decision around those changes. And we recently ran our legacy pensions webinar, and you can see a number of changes that we've done specifically there in respect to the legacy pension amnesty that's in effect now from the 7th of December last year. So let's kind of move back and keep things ticking along. Some of the things that are worth noting within our Smarter SMSF deed. Now, we do naturally have our governing rules, but in a lot of instances, well, in all instances with the relevant rules, we also have a guide. So that's a document. As part of the document, it just gives you some flavor, is probably the best way to reference it, around what that rule is designed to do. Now, it's not binding in terms of that, what the guide does from a legal perspective, but it's there as a way to help those that are the trustees of the fund and the members to ultimately understand what that rule is actually intending on doing. And the feedback that we get is that's very helpful for mum and dad who are our typical SMSF clients. We do have also things like special rules of the fund. So certain documents, it will allow for you to annex as if it was a embedded rule into the fund itself. So one of the things there that we have as a special rule is when you produce your pension documents, you can elect to call that a special rule of the fund, and therefore it's as if that pension was commenced as a specific rule within the actual deed itself. And the importance of that is that it then allows us to make decisions where agreed to between the trustee and the member to change the terms of that contract. So adding or removing a reversionary is a really good point there. Or equally, if we wanted to allow for, under the market-linked pension rules, the ability to commute that pension under what was previously a non-commutable pension, where, again, the rules of the fund allow for us to do so. One of the other things that we've done, which is somewhat unique to our deed, is the concept of a paramount document. So where there is a conflict in respect to certain documents where something has been nominated as a paramount document, it will take precedent, in essence, over one of those other documents. So things like a binding nomination versus reversionary, if you have one document nominated as that paramount document, then naturally that will override any provisions that may default within the deed in the first instance, which would typically reflect the reversionary pension there. Our voting and decision making is typically aligned to dollar of account balance in that regard. We've got things more, I guess, generic concepts within the deed around things like contributions now. So rather than having to prescribe things as we go along, as long as we're capturing those within an authorised contribution, being a contribution that is allowed under the superannuation and tax laws. Obviously, we've got the different elements of death benefit nominations and SMSF wills, again, following on from the changes that we saw off the back of the High Court decision of Hill and Zuda and a number of other cases in recent times as well. We've got the technology neutrality provisions. That's just a big word for saying that you can either sign in wet ink or through electronic execution. Of course, that alignment to the special purpose constitution before, and then the suite of documents ultimately are very much going back and connecting itself with the SMSF deed. So those pensions and BDNs that I just spoke about, but also the concept of something like a fund member's guardian, which we ran a number of sessions around some of these topics as part of our Smarter Legal Week in July last year. You can go up onto our website and you can find out more about those as well. And on the topic of legal review, I guess just an understanding of what the role of legal review looks like within this process. And I will touch on it as we go into the form as well. So the guiding principle here is that the legal review provides you with that peace of mind that legal review has been undertaken by the Hill legal team. It will allow for you to obtain legal sign-off on that deed of variation. So you'll get, there's a process built into the platform that will get that legal review completed. You'll get that legal review letter to say that it has been reviewed, and that liability shift ultimately goes on to the signing lawyer in that respect. In addition to that, it allows for you to utilise the Smarter Legal Review service to fix defective issues. So if we have a situation where we have a defective document in place, it may be a defective issue like a missing person, an incorrect name, a missing date, or any of those sort of things, you can utilise our deed of rectification or a similar sort of approach to ultimately get that fix done first before you then move on into that next phase, which is to then upgrade the governing rules. And there will be certain circumstances in more serious cases where the problem that exists as part of the chain of documents where you want to get the upgrade may be such that the risk to carry on is too great, and therefore the advice that might be provided is you may be better off actually starting again. So there is I guess a level of expertise that you can tap into as part of that overall process. And again, we've got this up on our website around our Smarter Legal Review. You can go to our legal section. This takes you into our legal review area. We also, as I mentioned, have our legal review week that you can see there as well. And you can find out more about the review levels and pricing and so forth as part of that overall process. And again, the webinars around the legal review and so forth as well that you can go and have a look at in your own time. So let's get stuck into some some of the, I guess, the stuff that we really wanted to find out more about, which is around the ordering process and some of the things that we've done at Smarter SMSF to assist you in that process. And I'll talk a little bit more about how that legal review process works as we work through the actual forms. So there are multiple ways ultimately that will allow you to complete a deed update. Okay, so we have our single order entry. Okay, so you can go into the form and we'll jump on that shortly. And you can also utilize a number of our platform features around our CSV import or our bulk ordering. And I might just quickly go forward to just highlight some of these two before we jump in. So a CSV import is in essence what it is. It allows you to drag in data from a predefined template CSV file to do multiple orders if you want to. You can do a single row if you want, but you can also bulk upload. So if you have an external data source that you want to use from Xero or an Xplan or something else that you may use as a CRM within your client base, equally, you could be exporting it from your SMSF software to do this, but you have the ability to use that CSV import feature. The other one, though, is if you are really using your SMSF software to undertake this process, is that we have our bulk ordering a way in which we're doing this. So you may have seen at our Smarter SMSF update recently for our members, we walked through this. So we will be putting that into our knowledge base for people to have a look at further. But this will allow you ultimately to sync to your SMSF software, add your clients, and then very quickly go through and create multiple saved orders as part of that overall process. So let's go back now and jump into the platform and spend a little bit of time navigating through that deed ordering process. So quite quickly, we can see we're into our main login of the platform here. I'm literally at our create new section. I'll touch on some of these other areas as we go. So we can type in here the ability to do our deed update. We'll be able to go down and we can see that information there. And it will include a description of what we have available as part of this process. So what to expect when we generate the order, how the integration works, how the legal review process works, things like links to the sample documents, along with the change log as well. So what I'm going to do is go in and we'll look at ordering that particular document. And what you'll see at the very beginning of this particular page is that it is going to allow you to connect to your SMSF software. So regardless of whether it's using Class, using Simple Funds 360, or using Supermate. So you can connect to your SMSF software. It will require you to undertake multi-factor authentication as part of that process. So if I just quickly do this, up here, I brought my phone with me. So that will enable me to connect, choose the relevant entity that we're going to be using. And then once we've done that, what we'll then see is the integration will become live. That will allow for us to then choose the clients that we want to, or client in this instance for single, will allow us to then go in and choose that particular client to undertake. And I'm just trying to see if I've got one in here that I can generate in this instance. Don't want to use the class one because there's not a lot of detail in it. Maybe I won't do. I'll just do the demo fund for this example here. I don't think I have a complete one in the system as a sample at this point in time. But what ultimately we're doing here is we're grabbing that data from your SMSF software, and it's going to enable us to then populate that order form with the information that we know. Okay, so that's the most important thing. The data that we import is only going to be as good as the information that you have within your SMSF software. So in here, we have our reference, we have our name, we have our fund, we have our relevant state. We have an address here that will also, we can validate as part of that process, so that will enable us to then choose that from the drop menu as we go down. We would have a date here. We can leave blank if we want to. And then it's going to come into some of these other questions that we don't know via the import, but we then need to know for the purposes of creating this particular order. So is it a QROPS variation that's happening? If it's yes or if it's no, that's going to dictate the template that will get generated as part of the completed order and all the relevant associated documents that come with that. We may have our history inside of the fund. If we have our history inside of the software, then this information will automatically get updated as part of that as well. So you can see here, we could have a number of upgrades as part of this process, and we would need to incorporate whatever that updated date was in that instance. If it is the Smarter SMSF deed, then it will automatically populate what that rule for the upgrade is. If it isn't, then you would need to reference that as well. You can see in here, we have a number of tooltips to assist you to work through that particular process. So in this instance, it might be 45.1. We're not using the Smarter deed, and then we may say in this instance that it's a rule. We have our different members. So that, again, that information has come through. We have the trustee type here. Are all members acting as individual trustees? We would select who our chairperson is. And then this is where it comes down to you understanding who else is involved in this process. So is there an additional party that needs to also sign off this deed? So is it a principal employer? Who is that principal employer? What is the details in respect to it? How many directors are going to be signing in that instance? All, et cetera, et cetera. Okay, so that equally could be a founder. That founder could also be the same person. It may be one person, put that person's details in, et cetera, et cetera. So I'm just going to go back to no there. And then equally, as part of this process, you have the ability to say, well, do I want to undertake legal review? So do I want Hill Legal to ultimately go and review the data collection and therefore the information that has been prepared previously in respect to this fund? So you can, in this instance, choose the level of review that is available within here. You'll need to go to the legal review to find out more about that. You would then upload the relevant deeds, the history of the fund here to enable that review process to be undertaken. You can provide some additional information that may assist as part of that process as well, and then acknowledge the work that would need to be completed as part of that overall process. And then ultimately you would end up with the ability to review that order and then submit that deed request as part of the overall process. So the form itself is quite intuitive. So it enables us, in this instance, I've got something that I haven't uploaded, so I might just need to attach something here. I might just attach that for the sake of submitting this order. It will allow, as I said, for you to review that overall process, the information that's within here, ultimately for the order that is to be completed for our members. So if you are a member, like I have in my situation here, if you have a subscription, that document is going to be deducted from the counter, i.e. you cannot see any price that is attached there. For those that are doing this on a pay-as-you-go basis, that will list the fee, and the credit card details will be required for you as well to submit prior to submission. You can save the order if you want someone else to review that, maybe a manager or something before that gets done, or simply you would then look to place that particular order. Now, there is an important step that's happened in here with the legal review, so I might just take the opportunity here to highlight what happens through that legal review process. If you don't request legal review there, then naturally this is going to be submitting that order, and then we'll generate the completed order for you in just a minute or two, subject to the amount of information that was included in that order in the first instance. So once that process is done, you'll naturally get redirected to the completed orders page. And what you can see in this instance is that it is subject to legal review. So what the step from here is the Hill legal team will be undertaking a review of the information, the scope of the work that needs to be done. And once that legal sign-off has been done, it will then allow you to come back and to then generate that completed order. All right, and it will require you to acknowledge that that legal sign-off has been completed, and we timestamp that entire process to ensure that that has been done, managing our own risk and managing the risk of Hill Legal, and ultimately that you've done all the right things that you want, because you wanted that legal sign-off to actually occur in its own right. So once that acknowledgement has occurred and that submission happens, then from that point of view, you'll then see that amber traffic light system here ultimately push through to then generate that order for you. So the legal document that you get with the legal sign-off and therefore the completed order will enable you to then have that completed overall process. So that's the deed of variation process more generally. Now, whilst that's sort of going, I'm going to hop over to how we can look at doing this as a workflow process. So I talked earlier about the fact that we can use a CSV import file here to actually undertake something like a deed variation project. So we can go and we can find that deed variation file. So we have a standard here, a sample, so a CSV file that we've built the mapping for. So you can download that information, and then you can use that CSV file to populate the various rows and columns to enable you to do that on a multi-fund basis. Okay, so in this instance, I will go in and I'll choose that upgrade form, click open, and then it's going to allow me to upload this information. Now, if you're using our template, this is a very, very easy process where you can simply auto map and all of those fields are then done for you. Now, if you want to create your own, you'll create your own for the first time. And then once that is done, you will then save that as a template. So you don't have to do that each and every time. So that's an important step. You might take a bit of time to get the template right based upon the export you might have from a CRM, for example. But once you have done that template for the first time, you save that template so that then as you complete it on the subsequent steps, you can then do that. You can choose from that template each and every time. That will save you a significant amount of time as you work through that deed update process for the following orders thereafter. And then once that process is done, that mapping process has been done, then ultimately what you're going to do is you're going to import that, and then it will, based upon the number of rows that you've done, if you've only done one fund, it will ultimately take you to the order. If you've done multiple funds, it will then create multiple orders for you to go and access via the saved orders page. So you can see in here, I only have one in here, so it's taken me to the actual page itself. Now, the other side to this is through the bulk ordering. So you may be managing your clients through a client list in here, so you can import your fund information via your class or BGL or Supermate software, or via the orders that you've done on the Smarter SMSF platform. So what we end up with is ultimately a client list. And the bulk ordering process enables you to then choose from that client list to create a number of variations for multiple clients. So it may be Smith, and we'll say beer, and we'll say Luke in this instance. And then because we're doing it with the variation and we have all the information about, which I'm going to close that one, and I'm going to choose that one. It enables you to very quickly process all of the information that we store in the client list to enable those deed updates to be done. So you can see how quickly I've chosen those particular clients. Now what I have here is I now have 1, 2, 3 orders now available to pick up and finalize. So I have imported 3 clients who I've chosen very quickly here to now enable me to complete that fund update process. All of the information that we hold in respect to that client in the data has been populated in here and will enable us to very quickly go and lodge or submit this information to enable that deed of variation to occur. So this can be done for 10 clients, 50 clients, 100 clients, saving a huge amount of time in the rekeying, but also not having to connect each time to your database as well. So you'll be able to see in here, we've got our fund, we've got our date, we've got our address, it's validated the state, it's got the meeting addresses, quite clearly things like for curates we don't have in here. If we have our fund history attached within our client list, then that information will come into here as well. So that data as part of the client list, if I go down to our Monday fund and we go in and view the history, we can make sure that the catalogue of our deed history would be inside here as well. So the more information that we have within our client list, the quicker it's going to enable us to not only prepare that document, but manage documents as we go along. And then our client list enables us to have a central repository for all this as well. So again, we've got Kylie in here as the member in this instance, the company, the corporate trustee, who the directors and chairpersons are. If we've got all that information again stored within here, we will then enable us to populate all that, and you can see all the detail that we have in here that will enable us to ultimately do that. So we do have a multiple of ways here to enable you to either A, order a document on kind of a one-to-one basis, but if you are looking at a project where you might be looking at multiple updates, then you can utilize either our bulk ordering function or CSV import function to save you a significant amount of time as part of that overall process. So let's jump back to our slides here and sort of take you home to this session today. So I've touched on that CSV. If you want to find out more about those 2 features, I refer you to our recent updates, Smarter SMSF updates, where we go through and look at, I guess, those features that we've developed in the Smarter SMSF platform. The other thing that we've been working on is the ability to create custom cover pages for our larger subscription holders. So this will include the deeds of variation. So you, in essence, allow you to design your own cover page for something like a deed upgrade, and then you'll be able to incorporate that, and it will then replace the default cover page that we have at Smarter SMSF. So there are some other elements to that obviously stay in terms of who that document has been prepared by and the legal disclaimers and stuff. All that information stays in, but purely from a branding exercise, you have the ability to utilize that, but it is limited to certain subscription holders. If you want that Create Plus package, it's not necessarily over $250, but it does incorporate the fact that typically it takes on board those that have much higher volumes that they want to do some specific bespoke work that suits them. Now, the other part of this that is really important to note is, well, how, once we've generated these documents, how can our clients actually sign these? So what I want to do is just to make very clear and reiterate here what the law is when it comes to electronic execution, because the Electronic Transactions Act is quite clear here that says if a Commonwealth law requires you to give information in writing, provide a handwritten signature, produce a document in material form, or record and retain information, then the Electronic Transactions Act here of 1999 allows you to do these things electronically. Okay, so that's the technology neutrality referencing that I had earlier. However, and this is the critical bit, the Electronic Transactions Act applies to all Commonwealth laws unless they are specifically exempted by the regulations of 2020. And in Schedule 1, it lists what those specifically exempted Commonwealth laws are. Now, currently, the only laws that are specifically exempted now are our SIS Act and SIS regulations, and that is item 89. So the Corporations Act in 2024, I think it was, or 23. Anyway, we saw now the entire Corporations Act now be removed from that exemption, which in essence allows for documents as a corporate trustee to sign in a technology neutral way. Okay. Now, individual trustees, you will need to reference the relevant state or territory-based laws and the witnessing requirements to determine how that document may or may not be signed using electronic means. Okay, so that's the most important bit. So if a law is exempt, then there is a requirement to still use a paper form or wet ink or retained paper-based information. Okay, so when we think about electronic signing, if you're going to use electronic signing, it is important to note that the law does not prescribe one single way to electronically sign a document. However, again, understand the different requirements at a Commonwealth, a state and territory law level, okay? But we do typically see a mirroring of that stuff. When we look at the Corporations Act around e-signing of a document, there are really two elements that we need to understand and we must meet. So one is around identification. So the method that is being used identifies the person and indicates their intention to sign that document, and it's recorded as part of that process. So see, you've got your section reference there that covers that. So identification is one. The second part is the reliability requirement. So the method that was used was reliable as appropriate for the purposes for which that communication was generated, or communication was proven, in fact, to have fulfilled the function in that identification requirement. Okay, so typically if you're using something like an e-signing platform, you're going to find that that will satisfy the above two criteria. Okay, so as long as you can identify who that person is and it's a reliable and appropriate approach to do that, then ordinarily that's fine. But, and I say this as but, because the fact is that because we don't have any action around our SIS-based stuff for some period of time, but the bigger issue is assessing the risk of utilizing the e-signing, okay? So the legislative standpoint is much clearer, but beyond the scope of what the law says, there may be some other external limitations to the use of the signing, okay? We do still have the third-party risk, so that third party, such as a bank, may have an internal policy issue that they may prohibit the acceptance of an electronically signed deed, even though the law allows us to do so. Okay, or there's a procedural risk that if we don't follow that properly, for execution or remote witnessing, then we may end up with an invalid document that could prejudice something that's happened thereafter. Okay, so you need to still think about these third-party and procedural risks. We've seen situations whereby that document has been electronically signed, something's gone into a financial institution to evidence a certain transaction that hasn't been accepted, and then therefore you need to go back into a deed of rectification to ultimately formally affirm that previous action, and then actually have wet ink applied under that scenario. So it creates more work ultimately just because of the fact that whilst the law has moved, not all procedures have ultimately moved with that as well. So I guess what else do we need to consider? And we'll touch on a few FAQs as we kind of wrap up today as well. So changes in legislation do not automatically result in a deed requiring amendment. So that's the first important thing. Look for prescriptive references in the deed that may be impacted by law change. So if the membership was prescriptive and limited it to no more than 5, well, then quite clearly, if you're wanting to add a 5th or 6th member, you're going to need to upgrade that deed. Typically, you would see referencing to membership in accordance with the superannuation laws that's not going to need an update because it simply moved the needle from 4 to 6. but equally things like downsizes, as we spoke about. But ask yourself, does the trustee or the member have any current or future need for the resultant change off the back of that? But that doesn't mean that you simply ignore the fact that you don't look at the deeds and the reviews. It should form part of standard business practice, making sure that the legislative change, you're keeping pace with it ordinarily, and then looking at those strategic opportunities around why that would make sense and how to best manage risk in different client scenarios as well. And what's on the horizon? I thought I'd be able to delete this by now, but we can't. We still don't know yet whether Div 296 will eventuate or not. We're getting very, very, very close to the end. But again, if it does come in, what impacts it's going to have, what changes might we need to make around those requirements as well. So you can see here a number of FAQs here that we get asked. Predominantly, I think we've answered most of these as we go along. We do have a copy of our sample within our knowledge base. Ultimately, we've covered the legal review stuff there as well. Our change log just, I guess, shows you that we do spend regular amounts of time looking at the deed. The fact that we provide so much education in this space gets us thinking not only about what's happening on an education front, but then how that impacts all of the documents that we have across our Smarter SMSF platform. And again, utilize the services that we have and our expertise to be able to assist you across not only the deeds, but a range of other documents that we have there as well. So some key takeaways. It is important that you review the trail of your funds deeds before undertaking a deed update process. Who's involved? What's the process look like? Who do you need to help you work through any of those questions you may have? You may come up with some problems. You do have the ability to remedy those problems, but make sure you remedy those first and you actually don't compound the problem by just sort of going through and getting that work done. Also think about, well, is there some other stuff in place that may get us thinking about, well, what do we need to do with this deed? Are we replacing the entire rules, or are we going to simply make some specific changes within there? And why do we need to go down that path? Do we also need to think about alignment with decision making? So are we making a change in the deed that would also get us thinking about making a change to the corporate trustee as well? And then ultimately what I've tried to demonstrate for you today through our platform is that there are a number of ways that you can leverage not only our specialization in this space, but also the technology that we've been building, real practitioner's approach. I guess myself being a practitioner, understand the ways in which we can make things more efficient and effective for you. So if you do have a project like deed upgrades, not only can you use the technology, but we have things like letters that you can provide to your clients that really frame up why it's important, what you should be thinking about, what you might want to charge your clients, and so forth as well. And you can get in contact with us and we'd be more than happy to give you a bit more of a demo as to how all that works as well. So I guess a couple of things just to wrap up here. A copy of the webinar slides will be sent to you shortly after today's session if you want to go back and have a look at any of that. We will be uploading the webinar recording in the next 24 hours for attendees, for our members. We will be putting this for CPD purposes up into our Smarter SMSF platform for you to access for our non-members. We will send you the recording on and be available for a short period of time for you to go back and, I guess, reference. And then after that, we will be removing access to that other than for our members via the platform. From a CPD point of view, we'll be issuing 0.75 CPD hours for our CPD members today. For those that are not, you can utilize this as unstructured hours. And I guess it's a great reminder that these sort of sessions, we do now accredit them for our CPD members. So if you want to find out more, I encourage you to become a member and find out and get access up to 25 plus hours of accredited CPD as part of our education solutions. So a big thank you for joining me today as part of Understanding SMSF Deed Variations. We do have a number of sessions coming up, our Changing Face, along with a little bit about our education as well. And of course, our SMSF Day events right around Australia kicking off on the 20th of March. So I hope you'll be joining us for one of those. Otherwise, I look forward to you joining us at an upcoming event in the near future. Have a great rest of the day and week. Take care and bye for now.